The charter school law, as it was originally proposed in Oregon, aimed to provide a lot of autonomy and regulatory relief to charter schools. The bill was actually amended more than any other law in Oregon history. What did survive the process was an important provision that allowed for contracting for services. The right to contract has been significant for Network Charter School because it has allowed us to hire and contract with several highly qualified community organizations. A year after the charter school law passed, the Attorney General was asked to provide some guidance on the contracting provisions. He was asked to give an opinion on whether, in particular, a for-profit organization could be a contractor for a charter school in the realm of education or administrative services. The Attorney General said, yes, the law seems to provide for nonprofits and for-profits to provide services for charter schools, but the charter school needed to retain a right of control over the contractor's services in the areas of, in particular, students' access to education, meaning their admissions, enrollment, and disciplinary process. And the charter school also had to retain control over curriculum development and instruction and any other regulatory item that was set up in the contract. By contracting, the charter school assigns certain tasks to the contractor. The right of control allows the charter school to step in to make sure the contractor is maintaining compliance with school rules, but also the issues with regards to a student's access to education and appropriate instruction and curriculum. The Attorney General also called for mechanisms for students, parents, and teachers to have an ability to appeal a contractor's action or decision. So all of these components were worked into Network Charter Schools contracts, with the help of the Eugene School District. Another major area of discussion centered on applicable law. The charter school law refers to 20 or 30, 40 other laws that charter schools must comply with in other statutes, federal statutes, state statutes, etc. A lot of those laws are applicable to contractors. The exceptions to the charter school law for contractors are mainly based on the fact that most contractors are non-governmental agencies. So in the case of Network Charter School, we have several nonprofits and a few for-profits, but none of them are governmental agencies. As such, they don't get to benefit from the statewide pension system, PERS, and they don't get the benefit of the limitations on tort claims. Contractors are not directly accountable to municipal audit law or statewide testing rules or the public records law. However, in each of those three cases, as far as the audits, as far as public records, and statewide testing, the contractors do help the charter school in its compliance with those laws. So if the charter school needs information regarding public records, needs assistance with any of these issues, the contractors are expected to help out the charter school in those areas. Finally, charter schools are subject to public meeting law and public entity union laws, and as these are only applicable to governmental agencies, the contractors can't be expected to publish their board meetings and be subject to public entity union laws. In the case of public records law, the charter school needs to be the main agent of compliance, and the reason for this is that the Attorney General needs to be able to indemnify and support the actions of a governmental agency when it comes to protecting student records. The Attorney General cannot be such an agent for a private or nonprofit entity. Similarly, with municipal audit law, contractors aren't expected to provide a municipal audit. A financial audit is sufficient. But in all these cases, the contractors support the charter school in its compliance with these kinds of regulations. Another issue related to governmental status is public meetings law and the public entity union laws. The charter school is is required to comply with these rules, non-governmental entities can't really support these kinds of laws. But for the most part, most of the rules that are applicable to regular schools are applicable to charter schools, and as such also contractors are subject to those rules too.